Tolentino.
Present po, Willie.
Lagota.
Present po, attorney.
Okay. Coral.
Present po, attorney. Good evening po.
Oh, I haven't called you last time, right? Mr. De La Cruz din. Ano ba?
Present po, attorney. Pinakos po.
Natawag na kita last week, no?
Yes po, tawag po. Reminder.
Okay. Mr. Fadriquela. Mr. Fadriquela. Absent?
Just to make sure
Kakain niyo lang po, sir.
Sige. I'm just gonna wait for him. Miss Horne de Repita.
Present po, attorney.
Sorry, it's very chaotic in the office right now. Please bear with me. But we have to finish this reputation because our last class will be next week. But am I audible? Can you hear me? Okay, nice. Mr. Gutierrez.
Present po, attorney. Good evening.
Okay, Beadle, where's your message on this one? Bahal, Corbillon. Okay, Mr. Corbillon is... Okay, Mr. Corbillon, next meeting ka na lang.
Yes po,
Mr. Coral. Yeah. Mr. Corbillon, Mr. Bahal. Grabe, brave souls. Talagang konti yung index card yung nipis. Pero Mr. Bahal was in the role of Mercy last time. Mr. Bahal, ano yun?
Yes po, attorney. I was.
Role of Mercy ka last week, di ba?
Opo.
So, okay ka na. And then, Corbillon, Coral, Padriquez. Oh, he's late. Mr. Fadriquez, are you here?
present po, attorney.
Okay. And then si Orbigoso na lang iniintay natin. Okay, let's start the recitation. Mr. Coral,
Good evening, attorney.
where are you? Wait. Okay. Okay, sige, let's start. Good luck. Question. Discuss the scope of the trust fund doctrine. Yeah, yun muna. Sige.
Wait lang po.
Okay. Go.
Hello po, attorney. The trust fund doctrine, attorney, means that there is a fund where the creditors may look for the satisfaction for the debt of the corporation.
Okay, so this is what you said just now. Trust fund doctrines is where the creditors have a right to look for the satisfaction of their claim. But that's the right of the creditor. Where's the trust fund doctrine there? Saan nila kukuhanin yung claims nila?
The trust fund doctrine is from the subscribed capital of the corporation.
Only the subscribed capital.
Also, attorney, the trust fund doctrine also includes those which is unpaid subscription of the stockholders.
Okay. So what will happen if a corporation is in a state of insolvency?
If the corporation is in state of insolvency, the creditor first may satisfy their claim on the trust fund doctrine, first on the subscribed capital, and if it it's insufficient, they may claim to the shareholders who or stockholders who have unpaid subscription.
Unpaid. So, are the stocks of those you mentioned with unpaid subscriptions called delinquent? Are they considered delinquent?
No po.
So what's the difference? Why aren't they automatically considered delinquent?
Um, Attorney, if I remember that before it must it can be considered as delinquent shares. It must first be declared by the corporation.
Okay, sige, that will do. Thank you, Mr. Gurang.
Thank you, Attorney.
Mr. Fadriquela?
Good evening, attorney.
Okay. Ready? Well, wala ka namang choice this time. So, yeah. Can a corporation release a subscriber from their payment obligations?
No, attorney. The corporation cannot release the subscriber if he has unpaid subscription.
Why?
Because the unpaid subscription will form part of the trust fund doctrine on which the corporation's creditor has the right to look up for.
Okay. Sige, kaya mo yun. Tuloy mo. Ulit. Because the subscriber has something to look for.
Because mga sinabi ko kanina.
The creditor?
The creditor
Okay.
as the corporation cannot release the stockholder with unpaid subscription, because the unpaid subscription will form part of the trust fund doctrine on which the creditor of the corporation has the right to look up for in case the corporation cannot pay the creditor.
So a corporation cannot at all times release a subscriber from their payment obligations
Yes, attorney.
at all times.
Yes,
Okay. How about the doctrine of indivisibility of subscription contracts? Okay, let's just go with this question. Can you issue a partial stock certificate?
No, attorney. The code, the revised corporation code, expressly provides that no certificate of stock shall issue unless the stock is fully paid. So therefore, there's no certificate of stock for partial payment of stocks.
Okay, so example, A subscribed for 40,000 shares but only paid for the 20,000. Can he get the certificate of stocks for the whole 40,000?
No, attorney.
No, not the whole 40,000.
Not the
What
whole.
if how many can he get? Certificates can he get?
You cannot get any certificate at all.
You cannot get any certificate. Are you sure?
That's what I recall in the RCC.
Okay, let's move to the next question. Do you remember the case of Bridwell versus Halley? I can give you clues if you want.
Yes, attorney.
Okay, ito yung he wants to collect the debt from the unpaid subscriptions. And Halley argued that she had fully paid the shares, presenting an OR. So, can the stockholder like Halley be held liable for the corporation's debt?
Only the subscriber only the subscriber who has not paid their subscription.
Was not paid. How about in the case of Halley versus Bridwell?
Sorry, attorney, I cannot recall the concern.
Cannot recall the case?
Yes, attorney.
Okay. Okay, last question. Can you remove the voting right of a preferred share?
Preferred shares do not have voting right on attorney. It's only the common shares.
Okay. So I can give preferred shares, and so if a corporation issues a preferred shares, automatically it has no voting right.
That's what I can recall. Yes, attorney.
All right. Thank you, Mr. Padrigala. Next. Is Mr. Orbigoso here? Wala pa din?
Wala pa rin po, attorney.
Okay, I'll just shuffle this index card together with everybody else.
Ito lahat pumasok.
Yeah, absent ka rin naman. Hindi, may ano kasi, may ulan. Hindi, mahirap yung scope namin din. Mr. Lagota. Somebody's cheering for you here. Let's go to the next part. Okay. Okay, for example, this is a scenario. In an articles of incorporation, it is stated that Class A shareholders can elect directors, but Class B cannot. So, is that valid under the revised corporation code? Close your eyes, Mr. Lagota.
Under the revised corporation code, it depends po if class A, it depends po on the classification of the class A share and class B share. For example, if class A and class B shares are both common shares, they cannot be deprived of voting rights. However, if the class B share is, for example, a preferred share, then it may be deprived of its voting rights.
But
Because-
as default, by default, does a preferred share has a voting right?
Yes po, attorney. By default, a preferred share has a voting right. However, such voting right may be removed from the preferred share because only common shares have voting rights which cannot be removed.
Any other kinds of shares where you can also remove its voting right? There's another one, right?
close it, ano pa.
Sorry po, I can't remember the other.
Let's just move to the next question. How can you remove a voting right of a preferred
Close
share?
it, lock it.
As mentioned,
Lock.
as you mentioned kasi, you can remove the voting right of preferred shares. Tama ka naman. But how can you remove a voting right?
The voting right may be removed by the voting right may be removed from a preferred share by stating it on the Articles of Incorporation.
Really? In the Articles of Incorporation, not in the bylaws?
Yes po, in the Articles of Incorporation po.
Okay. Let's move to the next question. Do you remember what a treasury share is?
Yes po, a treasury share is one which was subscribed and acquired but was subsequently reacquired by the corporation either through purchase and other lawful means po.
Are there any conditions required before you can reacquire shares like a treasury share?
To reacquire a share, the corporation must have the corporation must have an unrestricted
O sige, R is yung next initials ng hinahanap mong word. 3 words.
unrestricted redeemable stocks or redeemable shares.
Unrestricted retained earnings.
Retained earnings.
And do you remember what that means?
Unrestricted retained earning is this refers to the earnings of the corporation which are not restricted or appropriated for other needs, for other purposes.
Is it included in within the author is it included within the capital of the corporation?
Yes po.
It's included there. Okay. Thank you, Mr. Lagota. Wait, hold on. Okay, next person. Mr. Gutierrez.
Yes, what?
Wait, hold on. Good luck. Let's start with a corporation's power to acquire its own shares. It's somehow related to the treasury shares Mr. Lagota discussed a while ago. Can you give us a brief overview of this power of a corporation?
Yes, Potter. So the corporation has the power to acquire or repurchase its own shares as prescribed within the revised corporation code. So there are specific shares enumerated within the code wherein the corporation has the right to reacquire such shares, provided that the shares to be redeemed is already has already ano po, is already redeemable or is already ready to be repurchased by the corporation.
Okay. So, ano nga itong next question ko? Nakalimutan ko. We're talking about power to acquire its own shares. Can you give me an instance where a corporation reacquires its own shares? Like why? There's... Yeah, sige, go.
For example po, attorney, so ano po, for example, redeemable shares are can be repurchased by the corporation from its stockholders. So redeemable shares can be retrieved by the corporation where when these shares have already met its deadline, wherein the corporation has the right to claim it from its stockholders.
Okay, in relation to that, let's go to stock dividends. Can you give us an overview of what a stock dividend is?
Opo. So stock dividends are these are these are income provided to stockholders wherein the corporation has met or has collected or has so dividends, these are payments given by the corporation to its stockholders where when the corporation has met a specific target wherein this target shall provide dividends to stockholders. So dividends mainly are given to or has been prioritized to preferred stockholders, and after that dividends the difference may now be given to other stockholders. So dividends yun na po.
How do you declare cash dividends and stock dividends?
Sorry po,
Okay.
Okay.
I will not ask what is cash dividends kasi you discussed dividends already and you discussed stock dividends already. So what I want to know is how do you declare the
Yes.
Stock dividends and cash dividends kasi there is a difference, right? Okay.
Yes po. So ano po, the declaration of dissemination of dividends, classification of dividends may be posted with the corporation's bylaws po.
I'm talking about the votes.
The votes po.
There's a difference between declaring stock dividends and cash dividends.
Yes po. So when declaring stock dividends, so the corporation shall arrive to a voting wherein the majority of the board of directors have agreed upon, and in addition to that, 2/3 of the outstanding capital share members have also agreed to distribute stock dividends.
How about, okay, that's for cash dividend or for both?
That's for when distributing stock dividends to its shareholders.
So for stock dividends, you said you need the majority vote.
Of the board of directors. plus
board of directors plus two-thirds
2/3
of
of the members of the outstanding capital shares of the or the members of the company.
okay. How about for cash dividend? Is it the same?
Um,
Majority plus two-thirds?
for cash dividends, I think sa
Cash
unit,
dividends na tayo, no? Cash?
yes po, cash po. It's po, the same po.
The same. Thank you, Mr. Gutierrez.
Thank you po.
Next, Miss Paning Bata. Oh, okay, let's wait lang. Hold on. I'll just pin you in my list so I can see that girl. Next question is about the doctrine of apparent authority. Can you discuss?
The doctrine of apparent authority attorney is given with the officers of the corporation in which they are clothed by the authority from the board of directors to perform functions necessary to conduct the business of the corporation.
Okay, so is that so? What is the general rule when it comes to doctrine? When it comes to authorization of corporations?
For authorizations of corporations, it must be expressly granted or impliedly given with relates to the authority, with relates to the express authority given to a certain person.
Where can you find the express authority issued by the corporation?
In its charter or bylaws again.
In its charter, in its bylaws, there are express powers there. How
Yes.
about in our laws? Are there any mention?
Yes, attorney, there are certain authorities specifically specific authority given by the law.
By the law? Which one?
Just like because if there are no specific or express authority granted by the corporation, and the law will I'm sorry, attorney, let me repeat.
Okay, go.
There are authority given by the law if there are no express or clear provisions within the corporation's bylaws to protect the third parties again.
When you mentioned about express powers, you also mentioned about necessary, and there's also implied ones. So what's the difference of necessary and implied power?
They're actually the same attorney since for an officer to have an implied power, the acts that one performed is necessary or incidental to the conduct of doing business with regards to the corporation attorney.
You mentioned about the doctrine of apparent authority a while ago. So, what are the indicators that an officer or an agent of the corporation is clothed with authority to act on behalf of the corporation if we use that doctrine?
It is expressly given by the board of directors attorney, or it is expressly mentioned by their bylaws.
That's express power. So
Yes,
how about the doctrine of apparent authority? What are the indicators which will show that even though there's no express, it's not implied, it's not necessary, but he has an apparent authority to um, do business on behalf of the corporation? You still remember? O sige, can you just give me an example of where this doctrine can apply, even in cases?
In the case of let me just recall that. In the case of agro, if I'm not mistaken, or I'm sorry, allied banking, where
Versus Macam, right?
yes, attorney, where the officers entered into an agreement in which it is a lend, where they lend money towards the allied bank, and the doctrine of apparent authority is used here because the whether, even if the board of directors doesn't give express authority towards I forgot the name, towards the certain person who contracted with Allied Bank, by the means of ratification attorney, in which their previous acts prove that the board, whether without the express authority given to its officers, have ratified the transaction and gives implied powers to the officers in conducting the contract. So they are liable for the loan that it contracted, regardless of the authority given to them.
Actually, it's not a loan. It's about an earmarked fund that was allegedly
Yes, I'm sorry.
debited to Macam coming from another's account and all. But you're right naman when it comes to the doctrine of apparent authority there. Yeah, that's another case. Next, do you need to surrender the original certificate when you transfer the share?
No, attorney. It is not required to surrender the original in terms of transferring the share, so long as it only needs the payment,
Confederation.
yes, attorney, and the recognition by the corporation, and it's I forgot the other one, attorney. Consideration and the
Delivery and endorsement
by the other who transfers the share to another one.
Alright, thank you, Miss Panimat. Wait, 5-minute break. class. Are you back? Okay, let's go to the next one. Mr. Makalinam. Good evening. Good luck. So, do you remember the TCL case? The Teng? What's the title of the case again? The Teng versus SEC, where the corporate secretary of TCL doesn't want to register the transfer of shares because he wants because Ting Ting has not yet surrendered the original certificates. How did the Supreme Court rule in this case?
The Supreme Court dismissed the case because the surrender is not a requirement for
The surrender is what?
the surrendering of the certificate is not a requirement.
Not a requirement. And how did the Supreme Court characterize the role of the corporate secretary in when it comes to transfer of shares?
The corporate secretary is responsible for maintaining the records. So, for that, the registry of records for all the stocks.
Can you repeat again what are the requirements in order for a valid transfer of shares?
For the valid transfer of shares, there must be a surrender of the old shares to the corporate secretary and for it to be destroyed. There is an issuance of a new share to the new owner, and then the registration in the records of the
Let's go to the Nell Doctrine. Do you still remember this doctrine?
I'm sorry, attorney, I wasn't able to read it.
The Nell Doctrine. How about the sale of assets of a corporation? Have you reached that part?
One of the powers of the corporation is to sell the assets.
To sell assets. How about if you sell all? Is that allowed?
I think no po attorney. All assets to be sold. No po attorney.
Okay, next question. Last question. Do you still remember what a preemptive right is?
Yes, attorney. This right is granted to the existing shareholders whenever there is a new authorized shares before it is being sold or issued outside of the corporation. So this preemptive right given to the existing shareholder prevents their capitalization or share or proportionate share from the emission, meaning they will retain their own proportionate share in the corporation while the new shares is being offered prior to the new shares being offered to the public. However, this
Okay, sige,
is not absolute. However, this right is not absolute po, because it is one of the rights that is expressly, or this power is expressly, this is an express power granted in the code, new corporation code, meaning preemptive right is not an absolute right to the shareholders.
So you can deny a preemptive right.
Yes, okay.
How?
This is a corporation can deny this preemptive right if it is stated in the bylaws.
The bylaws, not the AOI.
In the bylaws po, attorney.
Alright. Does a preemptive right result to a stock split? Do you know what a stock split is?
Yes po, attorney. Stock split happens when the number of shares increase in number, but in total, when the total capital is not affected, however, the number of shares is affected. Let's say, for example, if there is a 2-in-1 stock split, meaning one shares of stocks will be split into two, however, the total value of the capital remains the same.
And does the exercise of preemptive right automatically results to a stock split?
No po, attorney.
But it can increase the number of stocks without increasing the capital, right?
Sorry, yes po, attorney.
But it's not automatic.
Yes po.
So what can you do to avoid stock splitting when when a corporation wants to how can a person exercise a preemptive right with a corporation not ayoko, ang hirap ng tanong. Basta, gets niyo naman ako, class, di ba? It's not automatic. Pwede naman kasi na nag-increase ka ng number of shares kasi you want additional capital. So, just amend the AOI, increase the capital, the authorized capital stock, and issue new shares. Therefore, walang stock split, right? Gets? Because of ako, hello, people.
Yes po, attorney.
Okay, let's proceed. Do you still remember the case of Aramay 1, Salido? The two groups, the Salido group versus the San Juan group.
So, the po, attorney, I was illegal in the case.
Okay, thank you, Mr. Macalino. That will do.
Okay.
Mr. Bahal.
Good evening, attorney.
How about you, Mr. Bahal? Have you read
Yes, attorney.
the Salido versus Aramay 1?
Yes po, attorney.
Okay, this is about reacquiring its own shares. Yes?
Yes po, attorney.
How did the Supreme Court rule in this case? Can the corporation validly reacquire?
The Supreme Court ruled in this case, attorney, that the corporation cannot validly reacquire the shares, attorney.
Why?
Because when the other group reduce the number of share or the percentage of share of, sorry, attorney, I forgot the names of
It's okay.
of the other
It's okay.
group. The corporation actually did not have unrestrained retained
Earning.
earnings, attorney, and thus they cannot consider the reduced percentage of share of that person as a treasury share. For that reason, attorney, they did not have URE, unrestrained retained earnings, attorney.
Okay, they don't have URE. Let's go back to the doctrine of apparent authority.
Yes, attorney.
How can it be shown that the corporation somehow ratified an act of its officer who has quote-unquote apparent authority?
Yes, attorney. There's a case assigned to us. However, I forgot the case name again. But in that case, The corporation must uh, accept or acquiesce, anong term yun?
Acquiesce.
Acquiesce
Something
is-
like that.
yes, attorney. The acts done by the corporate officer, affirming and in a way, uh, yes, accepting the acts done or the effect of the acts done by the officer, and thus clothing the corporate officer of the authority that his actions were actually authorized by the company.
Okay. So, Mr. Bahal, in the future, if you will answer from that case, you can state it like this. Jurisprudence provides that. When it comes to doctrine of apparent authority, ratification can be shown by the corporation's acceptance of benefits through the acts committed by the officer who has apparent authority, and whenever they allow the said corporation, the said officer to repeatedly engage in that, repeatedly act on that matter, something like that.
Yes,
Para
Walter.
it will be
Thank you.
more formal, and you can also answer in your exam like that. Let's proceed
Yes,
with
Walter.
a
Thank
question
you.
I asked a while ago regarding the Nell Doctrine. Do you still remember the Nell Doctrine?
Yes, attorney. Nel doctrine generally speaks of the buyer or the assignee not being liable for the liability.
Not automatically liable.
Yeah, not automatically liable of the debts of the previous company. However, there are exceptions, attorney. Actually, there are 4 exceptions. Number 1, unless the buyer impliedly or expressly assumes the liability. Number 2, the the buyer is just a continuation of the first company. And the other one is if the transfer is a merger or consolidation, and lastly, if the transfer was fraudulent just to evade the liability of the first company attorney.
Okay, before we continue class, if you will, ang una kong tanong when I read about Nell Doctrine is, why would you, I mean, binili mo yung assets ng isang corporation and then you will willingly, expressly assume the obligation of a corporation? Bakit? Gusto mo lang naman yung assets and all. So, when you analyze it further, kasi if you will sell or transfer all assets, it will affect the creditors. And we have this trust fund doctrine, right? So you cannot easily sell everything without hurting or kumbaga may bad effect to the creditor. So in order for them not to object or bring it to the court, etc., for fraud, etc., usually the buyer will agree expressly to assume all obligations of the selling corporation, of the debts of the previous corporation. So that's why there's an exemption. Okay, continue. Kaya pa?
Kakayanin pa, attorney, kung meron pang tanong.
Okay. Oo, meron pa talaga. Hindi ka pa tapos, Mr. Bahal.
Yes, attorney.
At masaya sila na hindi ka pa tapos kasi hindi pa sila magre-resign. Kung nakikita mo lang siguro sila, nakangiti sila lahat ngayon.
Ako po nahihirapan. Joke.
Yeah. Let's move to the next question. For example, a stock dividend was issued based on the percentage, di ba? Usually the dividends are distributed based on the percentage of your ownership or the number of stocks you have. So for example, a stock dividend issued to stockholder A is 6.6%. And for stockholder B, the issued stock dividend is 6 point, yung isa 6.6, yung isa 6.4. What is our, can a vote be worth 0.6? Or can a stockholder vote worth, can it be worth 0.6%?
Honestly, attorney, I do not know the answer.
Okay, so what can a corporation do in order to prevent scenarios where there are stocks issued with 0.6, 0.1, 0.3 shares to avoid this?
I also do not have the answer.
Okay, I'll just answer. You can, the corporation can exercise its right to acquire its own shares in case of that scenario, to prevent this kinds of divisibility of the shares. Para din buo, kasi yung awkward naman, di ba? Next, okay, last question, Mr. Basan. How about the TERP corporation case? The TERP case where a corporation, an officer promised benefits. Do you still remember that case?
Maybe I need more facts, attorney,
Okay.
for my recollection.
I'll just give you more facts. Ito yung may housing projects. Tapos nag-promise siya ng benefits, ng more benefits if in case mas maraming mabenta. And then, nung nagki-claim na yung pinangakuan, they're claiming that the one who promised more benefits is not authorized to do so. So, ring a bell na.
This case, attorney, is on the acts of the officer, not from the case, the acts of the officer is not from the board of directors, attorney. Tama po.
He's an officer, not a member of the board.
Yes, attorney. This officer's action was actually not authorized by the board of directors, attorney.
But does he have? But did the Supreme Court rule that the officer has an apparent authority?
In this case, attorney, the Supreme Court ruled that that officer did not have the apparent authority, attorney.
Alright, thank you, Mr. Bahan.
Thank you po, attorney.
Next. Just read the case, class. The answer is there. Miss Tolentino.
No, pwede.
Okay. Asan ka na? Ayan. Wait, I'll just pin you in my screen. Miss Tolentino, the Malcolm case was mentioned a while ago. Do you still remember the standard of diligence required for banking institutions?
For banking institution, attorney, it expressly provides in the revised corporation code that there should be a trust fund within the banking, including the insurance companies, and public utilities companies. Thus, the banking, the bank should have a specific trust fund for that specific corporation.
So only banks, insurance companies, only those you mentioned is required to maintain a trust fund?
No, po, attorney. All the corporation should have a trust fund. However, there is a expressly provides that what do you call this? It expressly provides that the bank should have a specific trust funds, including those insurance and public utilities that needs of funds directly to the public.
Okay. Ms. Tolentino, let's just clarify things. What do you mean trust fund? What do you mean when you mention trust fund?
Like in the bank corporation and the insurance corporation, it stated that there should be a specific transparency on the trust fund to the public because they are incorporating to the public's fund or money po.
Ah, okay. You're talking about trust funds set, like for example, for a baby, for like that?
Yes po, attorney. But, there is one case in the book that I read
Okay.
regarding those insurance, banking, and public utility.
Yeah, there is. But when we talk about trust fund doctrine, it's a doctrine na somehow like that. Kumbaga, di ba sa trust fund, usually sineseparate siya ng, for example, nangyayari yan sa mga mayayaman eh, if you remember class, di ba yung mga mayayaman, in order to secure the future of their kids, they will set a trust fund na hindi magagalaw not until the conditions are met. So that's the same. Kaya trust fund doctrine yung tawag. Hindi mo pwedeng galawin yung capital ng corporation kasi it's separated just to ensure na kapag naluki yung corporation, the creditors can claim from the reserve capital. So yeah, it's somehow like that, but it's not necessarily trust fund. It's a doctrine to, ano ko ba explain? It's a doctrine na somehow it looks like that, pero not necessarily separate. Well, a bank is also a corporation who needs a trust fund. An insurance company is also a corporation who also need, no, not just trust fund, to separate the capital. Okay, sige, I'll just accept your answer, Miss Tolentino. Let's move to the next one. Natanong ko na to. Okay, let's go to increasing and decreasing of capital stock. How can you increase or decrease a capital stock?
By the specific requirements, like the jurisprudence provides on the case, say that there should be a majority vote of board of directors. There is a specific documentation that needs to provide to SEC, and third, there should be a SEC approval, and
No, wait. Before you go out of the corporation, after the board, are there any other approvals needed?
yes, po, attorney. The approval of the 2/3 of the outstanding capital stock, and then the documentation, and then the approval from the SEC.
The approval from SEC. That's for increase and decrease. What will happen if, for example, for banks, kasi you mentioned kanina, the banks and the insurance companies, can they automatically do all this? Meron pa bang extra requirement for them to do before they start with the voting, the registration? Before they start the registration to the SEC?
Yes po, attorney. This is called the extra, I forgot the specific word po, but there is po extra requirement for banks, insurance, and public utility.
What's this extra? Ano yung extra requirement?
I forgot.
Okay, the extra requirement is the approval of the regulatory authority. So for example, it's a bank. You have to request the approval of BSP first. Insurance companies, you have to request for approval of the insurance commission first. Sorry, not approval. Endorsement of the regulatory entity. Why? Because these corporations are highly regulated. Example for banks, there are limitations as to the ownership of foreign entities, the ownership of Filipinos, and for example, when it comes to public utilities, there is a constitutional prohibition as to the foreign ownership. There's a constitutional requirement. Media public utilities. Okay, those are highly regulated corporations. Let's move to the question about what's the other kind of shares which you na pwede mong i-deny yung voting right?
The redeemable share po.
What's a redeemable share?
Redeemable share, it means that the shareholders already, the corporation already acquired the specific share, and then the shareholder needs to redeem that stock as his own.
The corporation shall. You mentioned shall, so
the corporation already acquired that share, and then the shareholder, one specific shareholder, redeemed that specific stock on his own.
how about the power to extend or shorten the corporate term? What's the requirement?
Sorry, but the extension of the corporate term.
Extension or shortening?
Okay, so the power to extend or shortening the term should be within 5 years, and if it's not approved or abandoned, it should be automatically extend the corporate term as it's specified.
Wait, to just get my syllabus. It's not again, sorry. If it's not
approved directly on that specific date, then the extension must automatically govern po.
For example, you want to extend the term. You want to extend the term for 2 years. When will the counting of the 2 years start? After the approval?
Yes, after the approval. However,
The counting of 2 years, or after the expiry of after the supposed to be expiration?
I'm sorry. Yes, po, attorney. I'm sorry. So, even though that the corporation is not yet expired, you can already extend or acquire the extension of the corporation. However, the start of the 2 years term is after the expiration of that of the initial corporation term.
You mentioned about the 5 years. So is it also required? Is it required that for both the shortening and the extension to be filed 5 years prior to the original expiration?
So, yes po, both shortening and increasing the corporate term po. Yes,
Both the increase and the decrease. Wait. This is from section 36. Okay, let's just proceed to the next one. How about the question about okay, that will do, Ms. Tolentino. Thank you.
thank you po.
Yes. Mr. Orbigoso, are you here?
Yes po, attorney. Sorry.
Hello, it's okay. What happened?
So, ano po, attorney, kasi po galing po akong sa looban po ng Valenzuela, and then hindi ko po alam yung lugar, so nag-try po akong mag-bukit na lang po pa-uwi. Kaso po, traffic po dun sa ano, kasi may baha po, and then meron po.
Yeah, buti na nga lang we decided to go to do online class today. Kasi nakita ko yung biglaang ulan. Sobrang init buong araw. Tapos biglang umulan. Shucks, oh my God. Hindi ko alam paano mag-face-to-face class ng klaseng ito. This is my first time to do to handle corporation law na puro online class. For the past few years, lahat ng yung previous corpo class ko were usually on face-to-face. Kasi I really do make an effort to go to UCC. Kaya lang this time kasi sobrang hirap. Okay, we will blame climate change. We will blame climate change for this. And it will go back to us. It's our fault. So, okay, therefore we conclude kasalanan natin to that. Mr. Orbigo, so let's start with the topic of selling of properties. Kasi we talked about selling all assets a while ago. How about selling properties?
Yes, attorney. This is an express power given by the corporation code, whereby the corporation has the power to sell their properties. Now, with regards selling their properties, in the provision of the corporation code, it can be classified whether it is a sale of substantial or substantial all or not. Now, as to the test of substantial, if the sale was substantial, sale of substantial all assets, the test is that would the sale of the properties would make the corporation impossible to continue its business. If yes, then it is a sale of substantial all assets. But if not, then but if the sale would still allow the corporation to continue, then it is not a sale of all substantial assets again.
That's selling of all substantial assets and not. How about selling in the regular business of a corporation? Do you have to call for a vote?
The corporation code provides that the selling of asset, if it is within the ordinary course of the business, then the vote is not required. It is required to if it is not if the selling of not the corporation, because such asset being sold would change would affect the corporation That attorney.
Last question. Let's move on to the topic of preferred shares of stock. What is a preferred shares of stock? What is share of stock pa lang? Sorry.
Shares of stock.
What is a preferred share?
Preferred share po is a share whereby it is preferred po as to, there is a preferential po as to the there is a preferential po as to the right po to dividend or on the liquidation attorney, whereby they would be preferred to be given they would be preferred to po be given the dividend or in case of liquidation over the common shares attorney.
So does a preferred share has all these preference or is it customizable?
It is customizable in a sense that the board will declare po the extent of their preferred shares authority.
Okay, thank you, Mr. Orbicos. Ilan na lang to? 1, 2, 3, 4, 5, 6. Wait, tama ba? Parang... Yeah. Okay. Pag di na ng class, matatawid na natin tong klase na to. 5 tao na lang. 1, 2, 3, 4. Ano na lang? Miss Orne, the representative.
Yes po, attorney.
Parang malungkot ka, Miss Orne, the representative. Pasensya ka na. Kasi kailangan trabaho lang to. Hindi ko naman ginusto na tawagin ka ngayong araw, pero parang malungkot ka. So, sorry. Sorry talaga. Okay, let's move on with the topic of equality of shares. What do you mean by the doctrine of equality of shares?
The doctrine of equality of shares means that all shares are equal in all respects, including liabilities and privileges.
So but they're talking about preferred shares a while ago. They're talking about voting rights. So there are differences between shares. How can you reconcile that with the doctrine of equality of shares?
All shares inherently have voting rights. So, however, preferred shares, the voting rights of preferred shares may be removed through by indicating in the articles of incorporation the removal of such voting rights.
The removal of such in the articles of incorporation.
Yes po.
What if, for example, you include so you just have to reflect it in the articles of incorporation in order to be valid?
Yes po.
How about in the certificate of stock? Do you have to put it there?
No po.
Just in the articles of incorporation?
Yes po.
Okay. Let's move to the topic of power to sue and be sued. Ayan. Okay. When it comes to corporations, how do you sue a corporation if it's not a person?
You can sue a corporation by... What's the question again, attorney?
How can you sue a corporation?
How can you sue? Although a corporation is not a natural person, it has a juridical personality. So, a corporation can be sued.
Mm-hmm.
It can
Oh,
be...
my question is how can... yeah, tama. It can be sued. Okay, go.
It can be sued by filing a complaint against the corporation itself, which may be represented by its officers po.
But one of the requirements if you're a natural person is the summons must be served. The subpoena must be served to the person. So how can you serve a summon or a subpoena to a corporation if it's not a natural person?
Summons may be served to the corporate officers such as the managing director, corporate secretary, treasurer, and other corporate officers po.
That's the rule. You should serve it to the officers, right?
Yes po.
How about if he's just an EA of the president? Kasi usually, di ba, kung pupunta ka ng kumpanya, tapos kakato ka doon, you'll barge in to serve the summon. You're in an ordinary day, you cannot just go through everybody, go to the office of the president and serve the subpoena and the summon. You'll usually pass through the EA or the or not the corporate secretary pa nga the EA of the president. So can you serve the summon to the EA?
No po. Only to specific corporate officers po.
How about the person manning the, what do you call that? The reception, yeah. How about the people manning the reception? Can you have it received by them? Is it a valid service?
I think you can serve it to the front desk or the person who usually receives communications for the corporation.
Oh, so what's the difference of the EA of the president with the person manning the reception?
The person manning the reception the person manning the reception, it's a part of her job to receive communications.
On behalf of the corporation?
Yes po.
How about the janitor of the corporation? Kasi halimbawa, ito yung scenario, pumunta ka dun sa office. 20th floor sila. Pumasok ka sa office. Ang naabutan mo, ay wala po, nag-lunch out po kasi yung reception. Ano po kailangan nyo? Kailangan ko po kasi mag-serve ng summon. Sige po. Sabi niya, nagmamadali kasi ako. Sige, sa'yo na lang isi-serve. Tapos, janitor siya ng corporation. Can you validly serve the summon to the janitor?
No po, because it's not part of his job to receive such communications po.
What if, for example, the receptionist, okay term na ako. What if, for example, the receptionist, in her job description, it's not included there that he's supposed to receive the summons it's not part of his job description to handle the receiving of any document. Is it sufficient enough to show that he cannot receive on behalf of the corporation? Kasi I don't think sa receptionist nakasulat sa JD nila, accept receive documents. Usually ang nakasulat sa JD sa job description ng mga reception to log in to facilitate the entrance of visitors, the exit, questions, directory, yan, nasa description yan ng mga taga-reception. But receiving documents, what if it's not there?
If it's not included in her job description, but in ordinary days or in the ordinary course of business, she receives such communications, the summons may still be served through her.
On behalf of the corporation?
Yes po.
And what doctrine is that?
Doctrine of apparent authority po.
Yeah, okay. Okay na, class? Na-connect nyo? Okay, nice. Let's move forward. What is sige, okay na yun. Sorry, kawawa ka naman. Parang galit ka na sa akin kasi parang di naman kita kinakawawa. Pasensya ka na talaga. Huwag kang mag-alala, babawi ako next meeting. Siguro tatawagin kita medyo una para medyo padali. Sana mabulot ka ng medyo una. Pasensya ka na talaga. God bless. Miss Nacario. Diyos ko, itong klase na to. Ay, nako. Miss Nacario, you here? Miss Nacario.
Good evening po, Atty.
Okay. Ready? Let's start with ultra vires acts. What are ultra vires acts?
Ultra vires acts, these are the illegal acts, attorney.
Illegal? So ultra vires acts are illegal? So,
Sorry. No, attorney. These are rights. These are the acts of the company or of the stockholders or officers of a corporation, which are they have the rights for these acts, attorney.
Wait. I'm confused. So, the corporation has a right. So, if it's his right, why is it ultra vires? What's ultra vires? So, I will call all rights of the corporation ultra vires?
Because it is contradicting to the public morals, attorney.
If it's contradicting to public morals, isn't it illegal?
And to the laws.
Hello? Yeah.
Yes, attorney, these are illegal acts.
Okay. So, if it's an illegal act, can you ratify that? Can a corporation ratify that?
No, authority. The corporation cannot ratify an illegal act or an illegal act po.
So, do you mean to say ultra vires acts are not allowed?
Yes.
Okay, let's move on to the next question. Shall we, class? Ito, Miss Nacario, have you read the case of majority stockholders of Ruby versus Lim?
Can you give me some facts, attorney?
Sure. This is about capital infusion. Wait. Capital infusion, the management committee, the MANCOM, without consulting the MANCOM, there was a board meeting, and then they authorized the capital infusion. So is it is it valid regardless if the MANCOM was consulted here?
No, attorney. Because in every action of a corporation, there should be a board resolution, attorney. And
Sige, continue.
I mean, it's authorized by the board of directors po.
Okay, wait, hold on. Okay, so I'm the last person in the office again. Somebody knocks to check if there's still a person here. Okay, Miss Nakario, last question. Do you know what a watered stock is?
Sorry, Ate, I don't.
Okay, that will do, Miss Nakario. Thank you.
Sorry po.
Okay. Bawi, Miss Nakario. Bawi, next meeting. Okay, so 4 na lang kayo, class. Lithuania, Abigini, Abigonia, De La Cruz. Miss Abigon, Miss Abigonia, hello? Are you there?
Yes, Father.
Okay. Ready?
Hindi po. Hindi po.
Pero wala ka namang magagawa in the first queue. Ito ko lang malaman. Baka kasi, may magbago. Okay, let's discuss again this case. The Ruby case. Do you still remember this?
Yes po, attorney. I remember some of it.
Okay, let's start with capital infusion. Because I included in the syllabus capital infusion. It's not part of the book. But I added a case discussing capital infusion. So what's your understanding of what capital infusion is?
Attorney, this case tackles about the shares of the company.
You're not answering my question. My question is, what's your understanding of capital infusion? Kahit based on this case.
Wait lang po, attorney. Attorney, sorry po.
Okay, let's just move to the next question. Okay, how about ultra-vires, Miss Abigoni? Para makaalis na ako sa ultra-vires, please. What do you remember about ultra-vires acts?
Okay. Ultra-vires acts, attorney, these are acts that are outside of the function, for example, of an officer to act. These are not acts which are necessarily illegal, but which are not given to such officers to do.
What is its difference with apparent authority?
Apparent authority, attorney. It can be said that an officer has an apparent authority if it is not by an officer to do an act, and that the officer has or
Sige, nasa tama ka na Miss Abigoni. Go.
the corporation is impliedly saying to everyone that an officer is their agent. But when it is an ultra-various act, attorney, for example, an officer did something which is outside of his jurisdiction or of his authority.
Outside of its authority.
Yes, po, attorney. And
it's not unusual.
yes, po, attorney. And there is no authority that was given to him by the corporation.
So, is it not allowed?
Generally, yes, po, attorney. It is not allowed because in that case, since the agent or the officer has no authority to do such acts, then in that case the corporation will not be liable for those actions. But if in case that a third person has relied on that
In good faith.
then the corporation
will be liable to that action of the officer.
Okay, so if I am suing a corporation for ultra vires act, all I have to prove is that I really believe in good faith that he has authority.
Yes po, attorney, that would do, but still there must be an evidence presented that the corporation has no, or that the corporation did show that it has given an apparent authority to that officer or not. But in such case, a third person who has relied in good faith that a certain officer was acting in behalf of the corporation, then he can sue that officer or the corporation.
Okay, last question, Ms. Abdeconia. When it comes to ratification of ultra vires acts, how can you show that, is silence allowed? Is silence considered a ratification of a corporation?
Yes po, attorney. Silence is one of the provided elements when it comes to an agency. It is provided in the law of agency, attorney.
So, wait, hold on. So if it's an element, every time
No.
it has to be required.
Sorry, attorney, it is not an element. It is provided in the provision of agency that an agent or a corporation may have ratified an act of an agent through his silence or through its silence. Through its silence for an action of an officer.
Okay, what if, for example, the corporation is silent? Kasi you mentioned, tama ka naman, silence is a form of ratification. It's implied ratification. But for example, the corporation is silent because he does not know that certain act is being committed by the officer. Can that still be considered a ratification?
No, attorney. For an act to be ratified by a corporation, the corporation must know the facts regarding the act that was made by the agent.
Yeah, because class, the danger here is, for example, the corporate officer is doing an illegal, this is ultra vires. The corporation is exceeding his authority on his own benefit, and the corporation doesn't know. That's why he didn't. That's why he cannot act about it. And since the corporate officer is exceeding his powers, that can be a ground for criminal action, civil action, among others. And the part that the corporation was silent for a long period doesn't mean it was ratified. It's just merely because he doesn't know. The corporation doesn't know. But once he knew about it, that's where it will start to matter. Pag nalaman niya at wala siyang ginawa about it, and then inulit ng corporate officer, there's an implied gratification on that na. Kasi he allows it to happen several times. But if the moment he learns about it, he did something, that will clearly show that the corporation did not ratify that act. And anyone who will sue the corporation because of that act made by the corporate officer or the board. We're not just talking about the board, the corporate officer. We can also discuss a member of the board committing that, or an employee of the corporation. Example, yung employee, di ba pinapangako niya sa lahat ng tao, bibigyan kita ng shares. Ilan gusto mo? 55? O sige, 55 sa'yo, 75 sa'yo, 35 sa'yo. Ganyan. And then the corporation doesn't know. Those scenarios can happen. And class, be mindful as to the timing, kung ano yung nasa facts. And medyo magulo yan, class. Favorite yung questions sa mga exams, even sa bar. Not just for officers, but also for employees, for board members. Just make sure that you check the facts carefully, and when you make a stand, explain why. Saan kayo nanggagaling? Kasi minsan, yung facts, hindi rin naman kasi complete. Mahirap magsagot, class, pero mahirap din gumawa ng tanong. Gusto ko lang malaman yun na kung nahihirapan kayong magsagot ng exam, na mahirap din gumawa ng tanong. Whenever I create questions for the midterms or the finals, I think about it several times. Minsan nga, napapanaginipan ko pa yung pagsusulat ko ng question Kasi, I have to make sure na somehow, dapat pare-pareho kayo ng magiging sagot. Kasi, if there's something wrong with my question, iba-iba kayo ng magiging sagot. So, magkakaiba yung appreciation nyo ng facts. And that's okay. In my exam, as long as you defend your answer well, you have legal basis, you applied it well based on the scenario, based on the situation I gave you from my question, I will accept that, provided na tama yung pagkaka-apply ninyo dun sa mga concepts, dun sa facts na binigay ko. Kasi, kaya nga may dalawang party ang kaso, di ba? Minsan 3 pa, 4, 5, depende kung meron pang other parties na other interested parties. So that means, minsan kasi, hindi minsan, always, may magkaibang version ang story. May magkaibang arguments na ginagamit. And we have to also make sure na yung question, pare-pareho tayo ng pagkakaintindi. Kahit majority lang, para kumbaga, madali ring mag-check ng answers. Hindi kayo maging iba-iba na parang, bakit may biglang alien na sagot dito? Hindi ko maintindihan. So, class, bago pa kayo mag-exam, para na rin kami nag-e-exam kasi we have to create the question and we have to prepare ano ba kasi yung expected namin na appreciation nyo nung question para malaman namin para mag-gauge din namin yung capacity ninyo to answer the question, the exam itself. So, ayun lang, just a few reminders kasi Beadle told me that that are supposed to be exam day is a holiday. And of course, kung ayaw nyo mag-exam ng holiday, ayaw ko din namang mang-torture ng holiday. I will not do that to you. And so, ayun, our last meeting will be, wait, Miss Abigonia, that's my last question to you, right? The Ruby. Sige, okay na yun, Miss Abigonia, pasensya ka na talaga. I'll just see you again next meeting. But don't leave the class yet because we still have 3 more students to recite.
Attorney corrections po. Kasama pa, po 3. Si De La Cruz po, Vitualia, tapos si Miravite. Tapos po si Albino.
Wait, again. Vitualia, De La Cruz,
Albino. Miravite pa po, attorney.
Oh, si Miravite pa.
Opo, 4 pa po sila.
Okay, sige. Ayun, so thank you, Bidan. As I mentioned a while ago, exam na natin next week. Kung di kayo excited, di rin ako excited. Tinatamad pa ang gumawa ng tanong. I don't usually repeat questions from my previous classes. You can check the questions just to give, di pala ako nagbalik ng questions. You can check their answers to see how, ewan ko kung paano. Pero, yun, you can check what my previous class had before. But I have to create new questions again. And to consider pa paano hatiin yung grades kasi baka maubos naman yung score nyo kapag ginawa. Ito kasi mahirap, class. I discovered this when I became a professor. Nung estudyante kasi ako masama loob ko pag marami yung question Kasi grabe naman, masakit na yung kamay ko, hindi pa rin tapos yung exam. Bakit naman 30 questions to? Yung 8 question lang, anak. The thing is, kapag konti yung tanong, nagiging 10 points each, right? Pag mali kayo, usually nagiging 2 points lang yung score, 3, 4. So, ibig sabihin, 6 points agad. Paano kung example, 3 question, mali ka talaga. Walang mali talaga yung sagot mo. So, ibig sabihin, 18 points na agad yung wala sa'yo. So, ilang mali mo na lang, babagsak ka na. Kasi in my class, ang passing score is 75. So, ilang kembot na lang, wala ka nang, bagsak ka na sa midterms. And ang hirap habulin nun sa finals kasi sa finals, isang buong libro na yung coverage natin. So, ayun lang, class. Please bear with us, professors, if we give you lots of questions. Kasi we're trying to give you more opportunities to get more scores. Yun lang, class. Para maintindihan nyo rin yung pinagdadaanan namin. Kasi kung nahihirapan kayo, nahihirapan din naman kami. Tapos walang nagsiscore sa amin. Ayun lang. But to be honest, class, I'm happy with the class's performance. The past few meetings. Mukhang naiintindihan nyo naman. Mas naiintindihan nyo tong corporation code kaysa nung second year ako na nandito ako sa corporation law class as a student. So, just bear with me. Medyo marami pa tayong concepts na i-discuss. Pero touch na natin yung different topics eh. The board, the stockholders, the members. Yun yung mga next topics natin bago tayo mag-merger and consolidation. So I think it will be easier for you to understand the next topics because you've been doing well naman, I think. Sana totoo. You've been doing well naman sa recitation. Parang naiintindihan nyo naman. Parang nakakonvince nyo naman ako na naiintindihan nyo. So, ayun lang naman. Sige, tapusin na natin to. 4 pa sila. Mr. De La Cruz.
Hello po, Attorney.
Okay. Asan ka? Mr. De La Cruz?
Hello po, Attorney. Hello
Ayan,
po.
nakita. Nag-hello ka. Okay. Mr. De La Cruz, what's the nature of a non-voting share?
So essentially, as a general rule po, a non-voting share has no right to vote in the course of the ordinary course of business. However, subject to such exceptions po as provided by laws such as first, the liquidation of the corporation, merger, selling of substantially all the assets of the corporation, liquidation, indebtedness,
Okay.
Yes. Sorry po.
How about amendments?
Sorry, amendments po, Attorney. Yes po, amendments of bylaws po, Attorney, and the EOA. Because they still have the right to vote.
What's a founder share, Mr. De La Cruz?
Founder shares, Attorney, it is the shares issued to the founders of the corporation wherein it was issued to the people who were in the articles of the incorporation's water from its inception of the corporation.
Okay, so you mean to say founders are only those found in the articles of incorporation?
Yes, Attorney.
What if I bought a share from a person who was registered as a board based on the articles of incorporation? I bought it directly from that person in the whose name was written in the articles of incorporation. Can I not be considered a founder?
No, Attorney, no po, because it was originally issued to that person who initially founded the corporation.
And what can you give a founder? what's the usual benefits of having a founder shares? Can I put a lot? Everything, sabihin ko, you can be preferred. You'll get massage, spa every month. Something like that.
No, attorney. No po, attorney. No.
Is there a limitation as to what can be granted to a founder shares?
The limitations that can be granted to founder share attorney, it must be inherently related to the official business of corporations, and next po, it must not be contrary to the laws, public morals, or customs of attorney and the revised corporation code.
How about the right to vote and to be voted for in the election of directors? Is there a limitation for that?
Election of voting of directors. Attorney, only the common and controlling shares of attorney are allowed to vote in the election of the directors.
So you mean to say a founder share cannot be classified as a common share?
It can be classified as a common share, attorney.
For example, this is the scenario, Mr. De La Cruz.
Yes po.
A has a founder share. So in his founder share, it was stated that he has an exclusive right to be voted for in the election of directors for 10 years from the date of the incorporation. Is that valid?
Attorney, 10 years from the date of incorporation.
Yes.
Doon
Is
na
that
po siya makaka-vote. Tama po ba?
No. The right to be voted for. It's an exclusive right to be voted for.
Attorney, it is valid po, attorney, as long as it was provided in the certificate of stock market.
Alright, thank you, Mr. De La Cruz. Dalawa na lang. Ay, tatlo pa sa ito. Next. Miss Albina.
Good evening po, attorney.
Where are you? Okay, ready, Miss Albina?
Yes po.
For the power for a corporation to exercise its power to increase or decrease capital stock, there's a notice required to be issued to stockholders, right?
Yes po.
What does this notice needs to contain?
The notice need to contain po the name of the corporations po, the reason of increase or decrease po of corporation's asset, that's all I can recall, attorney.
The what? The name?
The name of the corporation po, the reason of the increase and decrease po of the corporate assets po, attorney.
The reason? Okay, how about the place where the meeting will be held? Is that required?
Yes po, attorney. It is also required po.
Okay. So before we talked about articles of incorporation and bylaws. Where can you see the rules as to the place of meetings of corporation, of the meeting of the stockholders meeting?
The bylaws po consists of all the since bylaws po is like the government of the corporation, so including the meeting on how the special meeting and the general meeting po will be conducted is in the bylaws of the corporation, attorney.
does it mean to say that, or the increase or decrease of capital stock, does it have to always be in a regular meeting?
Not necessarily po, attorney.
So can you schedule a special meeting for the power to exercise your power to decrease or increase capital stock?
Not necessarily po, attorney. If the increase and decrease po of capital stock is in relation to the is vital or necessary po for the function of the corporation, the special meeting or general meeting po can be disregarded po, attorney.
The regular meeting can be disregarded?
Yes po, attorney. If the increase and decrease po in corporate asset is necessary po for the function or the vital and essential operations po of the corporate assets.
What about if the power to increase or decrease capital stock is gonna be part of the regular meeting of the corporation? So regular meeting, the schedule, the time and place of the regular meeting is usually found in the bylaws, right?
Yes po.
Okay, so if it's there, does a corporation need to provide notice? Still provide notice?
Not po, attorney.
No, so
Yes,
they mean
po.
to say it's automatic?
Yes po, attorney. It can be automatic po.
But without the notice, how would the stockholder know the agenda for that stockholder meeting?
Okay. Yes po, attorney. Sorry. I changed my answer. I misunderstood the question.
Okay.
Yes.
So, again, the question is, if the corporation will exercise its power to increase or decrease its capital stock, and this power will be put to a vote of the stockholders in a regular meeting schedule. Like for example, there are corporations who has stockholders meeting regularly scheduled once a year. So if it's scheduled on a using the regular schedule, do you still have to issue a notice?
No po, attorney. If it is part of a regular meeting po, it is no longer needed. The notice is no longer needed po. However, if it is needed po, if it is vital po, and through a special meeting.
Okay. So this is the danger class. Okay, Miss Albino, I'll hold your recitation now. I'll put it on hold. Class, you have to issue a notice. Kasi how would a stockholder, this is my point, how would the stockholder know that he's coming there to decide about the increase or decrease of capital stock, which will affect his rights as shareholders? That's why there's a preemptive right, class. I'll just connect the topics we have tonight. So that's why we have preemptive right. Kasi, for example, there's gonna be an increase in capital stock. So there will be more stocks to be issued in the corporation. So if ever your original share, your original voting capacity in the corporation is about 20%. And pag nag-increase yung authorized capital stock, mas liliit yung voting capacity mo, mas magiging ano na lang, from 40 magiging 29 na lang. That's why usually there's a preemptive right that can be exercised by stockholders, meaning you can go through, you can still buy more shares na i-issue, di ba mag-i-issue ng additional shares. You can buy additional shares up to the extent of your original percentage, the voting up to the extent of your original voting capacity, yung percentage, para ma-retain mo yung control mo dun sa corporation kung gaano ka-powerful yan, kung gaano ka-powerful dun sa corporation. That's preemptive, right? So, ba't ko nga ito dinidiscuss? Yeah, so that's why you need a written notice. Because you have to consider these factors. And the revised corporation realizes that you still have time. You need time to decide about this. Nanonood ba kayo ng Suits? Si Harvey Specter and all. Yeah, it's more related to corporation code. Kasi karamihan sa mga problema nila doon, problemang pangmayaman, mergers, consolidation, etc. Getting the vote of the board to pass this resolution, blah, blah, blah. They have to buy another corporation, how many votes. Nandun lang siya sa Suits. Hindi lang masyado malata kasi madaming drama. But, ba't ko ito kinakwento? Yeah, the stockholders must know beforehand kung ano yung agenda para mapaghandaan nila. Usually pa nga nag-uusap-usap pa nga yung stockholders eh. Halimbawa, kasi di ba, you need majority, two-third vote of all of those with of the outstanding capital stock. Okay? So, paano sila aabot ng two-third? Halimbawa, kailangan na talaga nila. Halimbawa, ganito yan, valid example. Yung company gusto nilang mag-expand. Gusto nilang gumawa ng bagong mall para mas mag-generate ng income. Pero they have to increase their capital in order to accomplish this business expansion plan. And they have to convince not just the management, not just the board, but the stockholders to increase their authorized capital stock in order to accomplish yung business expansion plan. And in order to do so, they have to justify to the stockholders that first, the company, the business proposal is a good plan that the corporation will earn, the corporation will kumbaga, it's a good plan to expand the corporation. Mas kikita tayo. Hindi tayo lulubog dito, stockholders. Mas kikita yung corporation. Pangalawa, kaya ng management na i-handle yung corporate expansion. We have the manpower, may contract na kaming nag-aabang with this corporation. Sila yung construction company. Nakausap na namin sila, bibigyan nila tayo discount. Ang committed nila within 5 years, mabubuo na yung building. Within 15 years, yung mga projections, within 15 years, mababawi na natin yung capital that we invested there, etc. So, in order to decide whether to go through with the proposal na increase yung capital stock, in order to, kumbaga, magawa yung business plan, you have to give them the things to consider early on. Para may isip na nila, tapos mag-uusap-usap na yan. Sige, ako, boboto ko ng yes. Hanggang sa makabuo kayo ng two-third vote. Gets, class? Nasusundan nyo na yung mga kaganapan as a corporation. So, yun lang naman yun. Last question, Miss Albino, nandito ka pa ba? Okay.
Yes po, attorney.
Can all corporations own land in the Philippines?
Not all corporations po in the Philippines can own a land. The exception po are those foreign corporations po, attorney. They cannot acquire private land po here in the Philippines, but they can acquire 40% po of 40% po when it comes to renting of condominium and leasing po of the land.
Renting of condominium and leasing of the land.
Purchasing of condominiums po and leasing of lands po, attorney.
But up to the extent 40% lang ng total ng condominium or nung isang unit dun sa condominium?
Condominium po, attorney, the total contract price po of the condominium.
Total contract price of the unit
Opo.
or the whole building?
The unit, the unit po, attorney.
So for example, for foreigner, so ibig sabihin, okay, sige, okay na yun, Miss Aldine. Thank you.
Thank you po.
Class, yung question ko will go with the grandfather rule of owning one unit versus the total ownership of the condominium itself. Nagigets nyo? Di ba kada isang unit, kung may foreign corporation doon, mag-grandfather kayo ng mag-grandfather. Tapos hanggang 40% lang. Gets? Hala, lumulutang na kayo. May dalawa pang magre-recite. Next, Mr. Miravite.
Attorney.
Good evening. Sana okay ka pa, Mr. Miravite. Masaya ka na. May natutunan ka naman ngayong gabi.
Okay.
Okay. Buti naman. Let's go discuss several types of preferred shares. Can you choose? We have cumulative and non-cumulative preferred share. What's the difference between the two?
Cumulative shares, attorney. Cumulative preferred shares, these are type of shares which if in the declaration of stock dividends, in the declaration of dividends to be for general, if example for the current year in 2026, the directors did not issue preferred shares or shares within the year. The following year, in 2027, the issue that's supposed to be received by the prepaid the owners, shareholders of the cumulative prepaid shares may be added or may be counted or may be included in the shares that will be issued for the following years. Whereas in the non-cumulative prepaid shares, if in the same given example, if the directors of the corporation did not issue a dividend within this year, and later on the following year they issue, the owners of the cumulative prepaid share may not be entitled to the share. The non-cumulative prepaid shares owners may not be entitled to receive the supposed dividends that he received in the previous year.
Okay, so I will not elaborate on that further. Let's go to the discussion about watered stocks. Are you familiar with what a watered stock is?
Yes.
Okay, go.
Watered stocks po, these are the type of stocks which the corporation or the directors allowed to issue where it was issued below the par value or issued on cash basis, and it was issued in exchange of a property, but the property paid for such subscription was not properly appraised, or it is example, if the property is 100,000 worth, but the director assent that it is more than 100,000 worth, that issuance is watered shares po.
And why is it harmful for a corporation to issue a watered stock?
Because it creates it is harmful, attorney, because it creates that the proper capitalization of the corporation was not properly accounted for in the book, in its books. So number one, it is against the law because the corporation must observe the revised corporation code, which it is forbidden um, to make a simulated declarations of the amount or the value of the shares po.
Okay, it's related to the trust fund doctrine. Kasi you're expected to reserve something for the creditors. So, and if you issue watered stocks, it will create an impression that is not realistic, that is not based on reality. So, parang nagbaballoon ka ng capital when in fact you don't possess that capital at all. So, okay, last question, Mr. Maravite. When still about the watered stock, what will happen if a director agrees to issue a watered stock? He did not provide any objection.
If the directors did not object, despite knowing that the corporation are issuing a watered stocks, the directors may be the assenting directors may be held solidarily liable to the third parties.
Alright. Thank you, Mr. Miravita. To the third parties, meaning the creditors or those who has claims against the corporation. Yeah, I still remember you, Mr. Miravite. You told me in the introduction that you want to become a lawyer and you will. So, yeah, I still remember that and I'm happy to be part of your journey. I'm grateful to be part of your journey. So, I hope you're still learning a lot in our class. I hope so. Kasi, ewan ko, minsan kasi, I'm trying to make the questions and the recitations lighter as much as I can. Kasi sobrang boring nitong klase na to, I swear. Last year, I remember, pag nagre-recite kami, sobrang kabado ng lahat ng tao. Sobrang kabado nila, kahit ako kinakabahan na din ako. Kasi hindi ko alam kung may kausap pa ba ako, naiintindihan pa ba nila ako, and everything else. So this time, I'll make bawi to UCC by, trying to make it lighter for everybody. But at the same time, making sure that you're learning something. I hope. At the end of this semester, let me know if wala kayong natutunan. Let's try to schedule a comprehensive discussion of the whole corporation code before after the finals, if wala pa din kayong natutunan at all. Kasi I don't want you to go to the next semester to higher year level without learning anything in the corporation code. Pag di nyo to na-gets ngayon, pagdating nyo ng 4th year, maaalala nyo yung mga terms, pero di nyo maaalala kung anong ibig sabihin. And walang mag-ring na bell. Medyo mas mahirap yun. So that's, ayun. Next is, the last one is Mr. Bitwalia. Mr. Bitwalia.
Attorney.
You will end this recitation for tonight. Good luck. Okay, let's go to the question of... We talked about preemptive rights a while ago, right?
Yes, attorney.
Can you remind us again what's preemptive right?
Attorney, it is a right given to the existing shareholders whenever there's whenever the corporation wants to acquire the its own share, attorney.
Wait, for example, you mentioned a while ago, it's only available to existing shareholders. So, for example, i-connect ko lahat ng inaral natin tonight. Ay, karamihan sa inaral natin tonight. Example, kasi ikaw yung summary, Mr. Bitwalia. Tandaan mo, ito yung pinakahuli. So, example, Mr. Betualia, binili ni B yung shares ni A. So, nag-transfer of rights sila. And then, Mr. Betualia, i-register pa lang nila sa stock and transfer book yung right. The transfer of shares can be exercise his preemptive right in case habang transfer sila merong tawag dito preemptive right can there's a scenario where preemptive right can be exercised.
Attorney, from the very start po, before a transfer of the stock po, there should be a preemptive rights on the part of the shareholders, attorney.
TA.
Yes, attorney. But then, if there's already a valid transfer of the stock, attorney, then the corporate secretary should record it in the corporate book of accounts, attorney.
It's ministerial for
attorney.
But can you now consider B as a stockholder?
When the elements of the valid transfer of shares have been made or undertaken, then there's already the presumption is that he is already the shareholder of the stock, attorney.
And he can exercise the preemptive right.
Yes, attorney.
Okay, Mr. Betualia, that is actually the answer I want to receive from my question a while ago. My original question was, can he exercise the preemptive right? But your original answer is the ministerial duty of the corporate secretary. So those are both okay naman. But make sure that when the exam comes, answer directly the question being asked. Kasi you don't have to explain the whole process. You just have to answer directly the question posed. Para mas buo mo makukuha yung score for that particular question. Kasi what if tama rin ako magbasa, hindi ko na tinapos, nasa dulo pa pala yung sagot mo about dun sa question ko. It will be detrimental to your grade. Plus, I'm starting to give you pointers na for your exam. Kasi, yun nga, niremind ako ni Middle kanina, malapit na pala yung midterms. So, try to take note of what to observe, how to answer the question so that you can properly prepare for your exam. Okay, Mr. Betualia. Last question. Ay, sinabi ko na ito. Oh, what are the exceptions to the power? How can you deny a preemptive right?
Attorney, the denial of the preemptive rights, attorney, can be made if it is provided in the articles of incorporation.
What if it's not provided? Okay, what if, example, ABC Corporation with an articles of incorporation that does not provide any denial of preemptive rights. It's not going to be absolute for the rest of the lifetime of the corporation. What if one day they want to deny it? Can they do that?
Yes, attorney, provided that the board of directors amended the articles of incorporation, attorney.
So it's just the board of directors who needs to vote in order to amend the AOI?
The majority of the board of directors and the 2/3 of the outstanding capital stock, attorney.
Alright, thank you, Mr. Betualia.
Thank you.
Yeah, you're starting to connect the lessons na. I'm so happy. So, yun lang. I didn't ask you about the cases now for week 4 and week 5 kasi I'm more particular with checking if naiintindihan nyo na yung concepts. Kasi kung naiintindihan nyo yung concepts, I'm sure you had easy, it was easier for you to understand the cases nung binabasa nyo na siya. Ako kasi class, pag nagbabasa ko ng ganito, I start with the book first para mas gets ko siya. And then I go through the cases kasi those are the application of what I've read sa book and sa caudal. So, wait, caudal book, cases. So, I will presume na nabasa nyo na yung cases and naintindihan nyo na siya based dun sa book. I really hope so. So, next meeting class, medyo madugo itong next meeting natin. This will be about the board of directors, week 6. Tama? Week 6, the board of directors or trustees. We've been mentioning the board several times. So, I think gets nyo naman na yung powers nila and yung usual nilang capacity. But this time, we'll cover, I checked the book, it's 100 pages, the coverage for the board of directors or trustees. I actually want to give you more time. Kasi, wait class. The schedule is, sorry. The midterm's supposed to be August 21, but August 21 is a holiday. So, we're gonna put the midterms August 14. That's the plan now. Except if you find the schedule that everybody agrees on, in between August 8 to August 20, midterm. In between August 7 to August 21. Kasi August 21 talaga dapat yung exam nyo, di ba? Kung gusto nyo mauna mag-exam, kayo bahala. Pero sabihan nyo ko agad. Kasi gagawa pa ako ng question class. Give me time to prepare the questions. So, give me a schedule. Okay, the default is August 14 ang exam. But if you find the schedule, if you don't want to take the exam on August 14, find the schedule that will match everybody's schedule. Kasi alam ko, iba-iba kayo ng schedule minsan. Iba-iba kayo ng load. So, find a common schedule for everybody to agree on. And then, let me know. So, I will give you until next meeting to decide if final na tayo, gora na tayo sa August 14, or if we're gonna move it. Okay? You have until next meeting, 9 p.m. to decide. Okay? I'm willing to move it kahit past August 14. That's favorable to me. And I think that's also favorable to you. But find the schedule. It's a face-to-face exam. So, hindi yata tayo pwedeng basta-basta mag-Sunday. Sunday is not allowed, I think, in UCC. I'm not sure. But if you find a schedule other than August 13, then let me know. Next week. Yun lang. Bye, class. Oh, any questions? Asahan ng digest today for week 5. Yun lang. Next week, week 6. Konti lang naman yung cases next week. 1, 2, 3, 4, 5, 6, 7, 8. Ang maganda yung cases next week. 9, 10, 11, 12, 13, 14, 15, 16. Okay, class ganito. I will waive the digests for next meeting. For week 6. I will waive just for week 6. But promise me, you will read the cases and you will read the book and the total. Okay? Be prepared next meeting. I will not require you to submit digest, but read everything. I will waive it. You don't have to submit any case digest for week 6 anymore. Okay? So, grabe naman yung saya. Grabe naman. Parang my birthday. Yeah, just to make sure that you can study well for next meeting. Kasi I understand that the scope, the coverage is long. So, read Codal, book, and case. I'll be strict next meeting kasi binigyan ko kayo ng more time to study. Okay? Wait, pwede nyo makiprint yung cases eh. And then yung digest nyo. You don't have to send to me something in handwriting for the cases. Okay tayo, class? Okay na, bati na tayo ah. Okay, yun lang. Thank you, class. See you next meeting. Bye.
Thank you po. Thank you po, attorney.
Bye, bye.